Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And this is another episode in our series entitled, You Mean I Have to Read the Preliminary Commitment? And the answer is yes, you do. And to help you understand what you're reading, Jake Mensinger has joined us for this video series. Would you introduce yourself, please?
Sure. Thanks for having me again. Jake Mensinger here, title officer down in Clark County with First American Title.
In this episode, we are talking about the broad category of foreclosure and what does it mean, or better yet, the importance of you reading your preliminary commitment for title to learn that the property is in foreclosure. You would think this is something that your seller would tell you. You cannot count on your seller to tell you that they're in foreclosure. And if the property is in foreclosure, then you have some very significant issues of which to be aware, most of them focusing around time. What are you seeing in the foreclosure era?
Sure. I looked before I came here today, and so I just kind of did from, a 45-day period, and we had about 42 notice of trustee sales recorded in Clark County in that time frame. Seems like a lot, but they're still out there, right? So they're happening, unfortunately for people, and so we've got to talk about them, right?
Right. So brokers, when you see on the title commitment or the seller has told you that they are in foreclosure, you now know that you have a significant timeline which you're working against. When the seller's notice of default is first recorded, that sets a timeline in motion that is in many cases going to be about 120 to 150 days long. And that could be the outer limit of how long they have to sell their property. Now, if that notice of trustee sale was filed 2 months before you ever take the listing, well, that means you have substantially fewer days to get that property sold and closed. What do you want to talk about with respect to this issue?
Sure. Well, we'll talk about how do you find it on your title report, right? So we don't have an exception that you're going to see numbered exception that says notice of foreclosure. So you're going to have to look at your deed of trust exceptions. It's going to list out the names, the amount, and then there'll be another subparagraph that may say, hey, this loan was assigned. That's normal, right? And then there's another subparagraph that may say, hey, we've appointed, let's just say, Quality Loan Service as the trustee. If you're usually a trustee is a title company or an attorney, but that's kind of my clue is when you see in a new appointment of successor trustee, and it's more of these companies that are doing the foreclosures. Okay. So that's kind of my first clue. And then you're going to see another subparagraph. If the notice of trustee sale is recorded, that's going to be under that deed of trust exception as well. So you kind of just got to look at your deed of trust exceptions, make sure, read them all the way down to the next exception. Make sure you don't have any of those sub-paragraphs that tell you. A lot of times then I would just go right to that notice of trustee sale, and what is that telling you? It's going to tell you when the sale is or scheduled for at the time it was done. A lot of times it may be postponed, or they may have information on how to get information on that notice of trustee sale on the document itself, right? So you can call the trustee, maybe get some specifics on that.
And there are government agencies, entities that have been created since the 2009 era, specifically intended to help folks who are in foreclosure walk through this process and maybe even challenge the process or try to build a recovery plan within the process. And maybe some of those entities can help them buy some more time, even if their goal is still to sell the property, help them buy some more time. I did not realize that the information about the being in foreclosure is so, I would say, embedded in the...
You would think it would bold, red, flashing kind of things to let you know, but it's really not. It's just in that deed of trust exception. So you kind of got to pay attention to that. Now your escrow officer should kind of see that right away and be able to say oh, hey, we've got this, but again, it's not glaring for you. You're not going to see it on that commitment with its own exception.
And the trustee sale is just as powerful if the escrow company notices it or doesn't, right? So listing brokers, has been the case with so many of these topics we've talked about, you just can't rely on anybody else to call these issues out for you. You have to know what you're looking for. And then you have to understand the significance of it. So if the property is in foreclosure, it is very important that you work with somebody. I would start with my managing broker, but you work with somebody, and your managing broker might call in maybe the firm's lawyer or somebody else who really knows what they're looking at with respect to the scheduling. Call in somebody who can help you figure out just how much time this seller has. And if the seller needs to negotiate for some more time, how do they do that? Who do they need to contact? What's the likelihood that they're going to get that additional time? At some point, they might need legal counsel. But certainly maybe one of these agencies could be their first step. But broker, it's going to be up to you to help them figure out the resources available to them so that they can get some of the help that they need. And if at some point it just becomes apparent that this property is not going to be able to sell and close timely, then the question for you would be, do I even want to take the listing? Do I want to utilize my resources to try and sell this property when the likelihood of being able to close a transaction before the foreclosure sale, not realistic? So those are the kinds of issues you need to be thinking about when you've discovered that property is at some stage. And there are so many different stages to the foreclosure process, right? There's pre-foreclosure notices and that have to be filed or that have to be delivered. I like the idea of seeing that it's been assigned to one of the companies that is typically the foreclosure trustees. I didn't even think about that being an issue. So brokers, if you're looking at your title commitment and you see that the deed of trust was recently assigned and you don't know if that's significant or not, pick up the phone and call your escrow officer or your title officer and ask them if they recognize the name of this company as being a company that traditionally forecloses deeds of trust. Because that could be a clue to you that you're not getting the full picture from your seller. Maybe the seller hasn't told you that they haven't made a mortgage payment in 6 months. Well, it's about to become evident.
And then the other thing is all the back interest, right? And if you're in the foreclosure process, they have an attorney. So now you've got attorney fees on your payoff also. So now are you in a situation where, do we have enough money? We're not in a short sale, are we? So maybe you might want to look at your figures a little closer too.
Yeah, or maybe we are in a short sale, right? That's your point.
Yeah, something to think about.
Yeah, no, that's
sure.
absolutely right. The payoff is not just the principal that's owed any longer. It's now the principal, all the accrued interest, fees, penalties, et cetera, et cetera. Good point.
Yeah. And so, and kind of I'll hit on that too, is like a bankruptcy. Like a lot of times maybe someone's filed a bankruptcy to stop that foreclosure. Again, I might not know about the bankruptcy. So if someone says bankruptcy, make sure you tell your escrow officer and your title officer, and I could do further searches, because the bankruptcy courts are different than what I'm searching on a regular basis. They're filed all over the country, right? So they don't have to necessarily file in Western Washington where I may look. So.
Yeah. And as a general rule, if the property is part of a bankruptcy, you're not closing a transaction.
Yeah. Well, and you'd want to know that, right?
You would want to know that.
Yeah.
Before you spend your time and resources marketing the property. That's right. At least it's not going to be sold quickly out of the bankruptcy process. Certainly it will eventually be sold, but it's not going to be sold probably by this seller and probably not on your 6-month listing agreement.
Yeah.
If you have any questions on this topic or any other, please ask me a question by visiting warealtor.org and following the links to the legal hotline. Thank you for being a Washington REALTORS member.